truth, logic, common sense, that gut feeling, and yes, even a little psychoanalysis. As we are once again together, you and I, to discuss what's going to happen on Thursday, y'all. The hussy wants a new trial. Now, I know most of y'all have got it down packed on what Archie and Thomas and Lori are belly aching about. But today we're going to go through the legal documents, and also, y'all, I have scheduled a live stream Wednesday evening. Be looking on the channel there. We're going to talk about why Lori doesn't need a new trial, and also why Lori needs life in prison. And here's the kicker, y'all. We're not going to talk about legality at all. Imagine that. No legal terms, nothing. This is all coming from my point of view, and I'm also going to put on the community wall a post so that y'all can get your word in, your content in, just out of just saying, hey, let's put aside the fact that she broke all these terrible, terrible laws, okay? This is why this woman does not need a new trial, and this woman needs to have life in prison. In fact, KJ's going to talk to y'all about what if, y'all, for sake of argument, that she got 30 years with a possibility of parole, which we know will never happen. But let's explore it anyway. Let's look at it together. And on top of it all, Wednesday evening in the live stream, we're going to talk about Chad Daybell, old Chinster there. Why? Why doesn't he deserve the death penalty, y'all? Should he get the death penalty? And if he gets the death penalty, what's that going to do for society as a whole? Is this got anything to do with inconsistent verdicts? Well, we're not going to talk about legality at all, y'all. We're going to talk about whether or not Chad Daybell deserves the death penalty, why he's going to either get it, not get it, a life sentence, or what about if Chad got 30, 40 years with the possibility of parole? Let's go down that road. Let's look and see what our imaginations, through everything that we've gathered thus far in this case, would say if Lori ever got paroled, huh? What would her life be like? I can tell you what, I've made lots of notes over my impressions of her personality, the people that perhaps would be around her or who wouldn't be around her. A whole absolutely Pandora's box will be open Wednesday evening. I hope you'll join me, Rays. And again, that community post is coming. So if you've got something you'd like to say outside of what? Legality. Wednesday evening, y'all. We're going to do it to it. I guess KJ's probably going to let my imagination run wild. But then again, we're going to be talking about legality today. Last time that we met, we were talking about, this is coming up. Lori's going to have this hearing. We found out through the portal that the victim impact statements, I won't go into all that. I think it's a crock of shit. Cresha K. Easton, Larry Woodcock, Annie Cushion, others, their voices should have been heard. I hope they'll go on national media and let us all know. I think it's an important lesson for all of us to hear from all these people that will not be able to speak at Lori's sentencing hearing, July 31st. But the bottom line is it is what it is, and it's all because of what? Legality. It's the statutes, the codes, the rules in Idaho. And so Wednesday, we're going to throw all that out the window, and we're going to talk about it. Lori and Chad. And also, if you want to throw in there, who else deserves a freaking pitchfork with stringing them up in the dang courthouse lawn? We'll just see what everyone's got to say. But once we got together, again, I knew that the state at some point would come out before Thursday with their objection and memorandum in response to the defendant's motion for a new trial. And y'all, I mean, I could sit here and I could say, well, there's 3 reasons out of the 7, we'll go into it, that Archie and Thomas has got out here. We kind of touched on those, and let's just leave it alone, but you know how I am. Ever since I opened this channel, even though I'm no legal expert, I'm a layperson in all of this, I wanted to be able to go through it as best as I could so that we could all get a little justice through understanding. And perhaps maybe because I'm such a simple-minded person that we could really flesh this out. Again, today is going to be about legality, but Wednesday is a whole different ball game. So anyway, we're going to start on this, and I'm going to try my best to break this down. Some of y'all have read the court documents, and some of you have not. And so I want to put it on the channel so that everyone gets a chance to really hear the whole full meal deal from old KJ, all right? Okay, so the state objects, obviously, to the defendant's motion for a new trial and submits the following memorandum in support of the state's objection. And the state starts off with the factual and procedural background, basically letting everyone know where we've been and where we're at, you know. And they say on May the 12th of 2023, the jury returned a verdict of guilty against the defendant for the following: 1 count of conspiracy to commit first-degree murder and grand theft by deception, wherein Tylee Ryan is the victim. 1 count of first-degree murder, wherein Tylee Ryan is the victim. 1 count of conspiracy to commit first-degree murder and grand theft by deception, wherein J.J. Vallow is the victim. 1 count of first-degree murder, wherein J.J. Vallow is the victim. 1 count of conspiracy to commit first-degree murder, wherein Tamara Daybell is the victim. And 1 count of grand theft, wherein the United States government is the victim. On May the 25th of 2023, the defendant filed her motion for a new trial, which has been set for a hearing on June the 15th of 2023. Now, here's the law and argument. This is the state's going to lay it out, and I'm going to try to break it down. First, I want to say this, y'all. There is a rule in Idaho, and there's a statutory code. Those are 2 separate things, okay? But they've got to come together, and you'll see what I'm talking about. Idaho Criminal Rule 34A provides in part, on the defendant's motion, the court may vacate any judgment and grant a new trial on any ground permitted by what, y'all? Statute, the code, right? So a rule, there's a rule, and there's a statute/code. Okay, those are 2 separate things. The statute referenced by Idaho Criminal Rule 34 is Idaho Code 19-2604, which provides when a verdict has been rendered against the defendant, the court may, upon her application, grant a new trial in the following cases only. Okay? So this is the statute saying, okay, the Idaho Criminal Rule has said, hey, this is the statute. And the statute says there are 7 reasons, okay? Nothing else. Just 7 reasons by this Idaho Code 19-604. Number 1, when the trial has been had in her absence, if the indictment is for a felony, and we know, y'all, she was there the whole damn time. She was in the courtroom. She tried to get out of seeing the damn handiwork of her and that damn asshole. The bottom line is she was present during all of it. Number 2, when the jury has received any evidence out of court other than that resulting from a view of the premises. Number 3, when the jury has separated without leave of the court after retiring to deliberate upon their verdict or being guilty of any misconduct by which a fair and due consideration of the case has been prevented. Number 4, when the verdict has been decided by lot or by any means other than a fair expression of opinion on the part of all the jurors. Number 5, when the court has misdirected the jury in a matter of law or has erred in the decision of any question of law arising during the course of the trial. Number 6, when the verdict is contrary to law or evidence. And number 7, when new evidence is discovered material to the defendant and which he or she could not with reasonable diligence have discovered and produced at the trial. Okay, so there are the 7 reasons in the actual Idaho Code and statute. And those 7 reasons are pointed out in what? The Idaho Criminal Rule 34. Now, the state talks about the different case law, the precedent that's been put on this, and the state wants to highlight this. In State versus Cantu, the Idaho Supreme Court reiterated, "We have concluded on prior occasions that Idaho Code Section 19-2406 sets forth the only grounds permitting the grant of a new trial and therefore limits the instances in which the trial court's discretion may be exercised." And what that's saying is because this statute has 7 reasons, they're backing it up by State versus Cantu by saying, even though the judge has discretion, they have to go by these 7 reasons in Idaho statute. They can't do anything else. They have to look at those 7. And then it talks about State versus Gomez, State versus Langford. And it talks about, although Idaho criminal rule, right? This is a rule. This isn't the statute. This is the other thing. This is the Idaho Criminal Rule 34. Allows a trial court to grant a new trial if required in the interest of justice. This court has concluded that Idaho Criminal Rule does not provide an independent ground for a new trial. What is that saying? It's saying that, hey, here's an Idaho criminal rule that says in the interest of justice, you can grant a new trial, but it can't work independently of nothing. It has to have what, y'all? It has to point and be added to what? An Idaho code, an Idaho statute. State versus Davis backs this up, and then it says, rather, Idaho Criminal Rule 34 simply states the standard that the trial court must apply when it considers the statutory grounds. It just simply states the standard. It's a standard. And the standard is what? The Idaho Criminal Rule 34 is saying, here's the standard. There's 7 reasons according to what? Statutory code. Remember, y'all, these are 2 different things that have to be put together. A motion for a new trial may be granted if the criteria, and the criteria being one of those 7 reasons, or all 7, or any of them, if the criteria of Idaho Code 19-2406 and Idaho Criminal Rule 34 are met. First, the statute and the rule require that the defendant make a motion for a new trial. Second, the motion must be granted on one of the grounds enumerated in 19-2604. And finally, the grant must be in the interest of what? It's in the interest of justice, which goes back to the Idaho Criminal Rule, in the interest of justice. Neither the statute nor the rule prohibit the grant of a new trial on grounds not argued by the defendant, so long as the defendant has requested a new trial and the ground relied upon by the court is one of those specified in the statute. Now, we know Archie has 3 out of the 7 that he's put in his motion for a new trial. Well, this rule here and the law about it is even if Archie left one out, let's just, for sake of argument here, we know one of them was new evidence. He doesn't state that in his motion for new trial. The judge can look at all 7 of those, whether Archie brings them up or not. Looking to the 7 potential grounds for a new trial, the state now is going to tell us what they see in all this. The grounds that Archie and them are bringing out. Number 1, we know that the first thing was when the trial has happened in the absence of Lori, right? Well, we know that's not true. It says right here, it says, number 1, the defendant was present for her trial. So they've marked that one off. Number 2, the defendant asserts the jury considered evidence not introduced at the trial. However, there is nothing to support the defendant's assertion. And of course, I'm scratching my head about it because they don't go on to explain why that nothing has been brought out. I guess this will be when they have their motion hearing on Thursday, they'll go into more specificity. But they're talking about reason 2 of the code there is that Lori asserts that the jury considered evidence not introduced in the trial. However, there's nothing to support the defendant's assertion. Number 3, the jurors remained through the deliberation and the verdict. And again, this goes back to the statute where it talked about when this is a reason you can give her a new trial. The jury has separated without leave of the court after retiring to deliberate upon their verdict or been guilty of any misconduct by which a fair and due consideration of the case has been prevented. In other words, the statute's saying if the juror members didn't do what they were supposed to do in terms of going back to the juror room before deliberations or during deliberations, or even when they retired to go home, or there was any kind of misconduct, well, Archie says the jurors remained through, the state says the jurors remained through the deliberation and the verdict, and we know that there was nothing ever said or brought up in the trial that, hey, something's going wrong here. As you recall, the only little disruption, which was absolutely legal and normal, was when one of the jurors got sick. Remember that? And they had to replace that juror with an alternate. It was never anything brought up that the jurors had done anything wrong. In fact, as many of y'all know, when a criminal case is being tried, Judge Boyce every day would ask, have y'all seen anything, heard anything? And raise your hand if you've seen or heard anything. All of them had done their due diligence. Number 4, nothing has been alleged, nor is there any support that the verdict was decided by a lot. To the contrary, each juror answered yes as to the verdict when polled. So again, this goes back to one of the statutory requirements was number 4, when it talked about when the verdict has been decided by lot or by any means other than a fair expression of opinion on the part of the jurors. In other words, they didn't go in there. They might have had times in there, we'll never know, where they gave hey, where are we all at? Let's just take a vote. But that was, a vote is different than saying, okay, if 8 of us or 10 of us or 11 of us say guilty, then you, juror over here that says not guilty, you have to give in, and it's not really your opinion of it, but we're all good because we're a majority or whatever. There was never any evidence at all that any of that went on. Again, each juror answered yes as to the verdict when polled. Number 5, the defendant contends, all right? Lori contends that the court misdirected the jury in a matter of law or has erred in the decision of any question of law arise during the course of the trial. However, the state opposes this assertion, and I'm assuming they don't go into detail in their memorandum, which I would have hoped if they would. The bottom line is I think this has to do with the 404B material. Remember this, y'all. To bring in past acts of Lori from Arizona, remember that was about only they could use it. The jurors could only use it as motive. But remember, the content, the introduction of the jurors finding out about Arizona. That was the information. But they're also talking about the demonstrative stuff that came with it, stuff that was up on the screen that had to do with Lori's past bad acts. In other words, what I'm saying is for instance, Alex Murdaugh, they brought in 404B material and the jurors were made aware of his financial crimes, right? Well, that's one thing in 404B, but another thing is the exhibits that the jurors actually saw, which would have been for demonstrative purposes. So you see, 404B is the information and also what you visually would see as a juror, okay? The defendant contends the verdict is contrary to law or evidence, which is number 6. But there is nothing to support this contention. Now, let's stop for a minute. Archie and Thomas have crafted this motion for a new trial. I'm not saying Lori obviously is saying herself, she's leaving it to her attorneys to say that the verdict is contrary to law or evidence. The bottom line is the damn hussy had a mountain of evidence that she couldn't overcome. Archie and Thomas knew it. The bottom line is she got her speedy trial and she can shove that contention right up her damn nasty ass, okay? And number 7, there is no allegation or assertion of new evidence. Now, again, as we began talking about this legal document, it is in law that just because Archie brings up only 3 of the 7 doesn't mean the judge can't look at all of them. But there was never anything said in this trial about that DNA evidence floating around out here. So that cannot be considered. Now, the defendant focuses her argument for a new trial on Idaho Code 19-2604, subsections 2, 5, and 6. So the state is pointing it out of all 7 of them, you got number 2, number 5, and number 6. But again, according to law, the judge will look at all 7. Looking, let's see where we are. 2, 5, and 6. Okay. I lost my place, y'all. Okay, here we go. Excuse me. Looking at 7 potential grounds for a new trial, we got past that. The defendant focused her argument on 2, 5, and 6. Excuse me, y'all. I got a little mixed up here. Okay, so now the state is going to go into all of that. That Archie and Thomas and Lori have looked at, in the statute, were 7 reasons. And the Idaho criminal rule is saying, hey, look at those in the interest of justice, okay? So here we go. The state says, the court properly instructed the jury in relation to the charges for conspiracy. A criminal conspiracy is defined in Idaho Code 18-1701 as this, and the state wants it on the record, that if 2 or more persons combine or conspire to commit any crime of offense prescribed by the laws of the state of Idaho, and 1 or more such persons does any act to affect the object of the combination of the conspiracy, each shall be punishable upon conviction in the same manner and to the same extent as is provided under the laws of the state of Idaho for the punishment of the crimes or offenses that each combined to commit. Pursuant to the plain language of the statute, the defendant was on notice that she was accused of conspiring with 1 or more persons to commit the underlying offense contained in her charges. And this talks about how Archie was saying, hey, we were put on notice about a year ago that there was at least 5, and we were misled. And so the state is saying, hey, this ain't got nothing to do with 5. This has to do with the actual Idaho Code, 2 or more persons combining to conspire, and 1 does something to affect the object of the conspiracy, right? In State versus Yang, so the state is saying, okay, so Archie's saying that there were 5 people that they were under the impression was conspiring and all this, and they only talked about Chad, Lori, and Alex in this trial. And we think this is grounds for a new trial because we was misled. But now the state is going to talk about a precedent, another case. And this is the State versus Yang. The defendant argued, hey, there was a fatal variance between the elements instruction for conspiracy to traffic in marijuana and the second amended information charging him with that offense. The court determined, though, a variance between a charging instrument and a jury instruction necessitates reversal only when it deprives the defendant of the right to fair notice or leaves him or her open to the risk of double jeopardy. In Yang, the second amended information alleged that Yang did willfully and knowingly combine, conspire, confederate, and agree with SC, DC, and KE. These are initials for other co-conspirators, y'all. The district court instructed the jury on the elements necessary to find Yang guilty of the conspiracy charge to include 3. And the defendant, Ching Yang and SC and DC and or KE agreed. Yang objected to the use of and or in the third element of instruction 18, arguing that the term made the instruction inconsistent with the conjunctive list of co-conspirators alleged in the second amended information. And the district court rejected Yang's argument, concluding that the jury instruction could list the co-conspirators' identities disjunctively when the charging document listed them conjunctively without creating a fatal variance. On appeal, Yang argued that the district court erred because by listing the co-conspirators disjunctively, Instruction 18 relieved the state of its burden to prove the existence of an agreement between all of the co-conspirators alleged in the charging document to commit the crimes of trafficking in marijuana. That is, Yang alleges that Instruction 18 deprived him of fair notice of the charge against him and prejudiced his defense. So that's what he was saying on his appeal. That because the original one had a couple of them, and then there were 3 of them, and then they added the language and or, the bottom line is he was trying to get this on appeal, and guess what happens in the appeal? The Idaho Court of Appeals found the use of and or in Instruction 18 did not create a fatal variance. Idaho Code Section 18-1701 requires that a defendant have an agreement to commit a crime with any one other person to form a conspiracy, not the number of individuals pled in the charging documents. In other words, all Lori had to do was have a conspiracy with one other person. It didn't matter if there were 3, 5, 10. All they had to prove, according to Idaho law, was just one other person. And we know damn well there's evidence of Alex and Chad. But just for sake of argument, the bottom line is if it only had been one other person, say she conspired to murder everyone with Chad, and she had no idea that Chad was going to use Alex to do it. The bottom line is she gets charged with murder and convicted of murder, even if she didn't know what Alex was doing. Although we know different, right? Additionally, the identity of a co-conspirator is not a necessary element of the crime of conspiracy. Lori didn't have to know everyone that was co-conspiring with her, according to Idaho law. And that was also talked about United States versus Ray, holding that no constructive amendment occurred when the district court substituted the name of the defendant's wife with the phrase another individual. In other words, what they're saying is you could specify the person's name, or you could say a co-conspirator. You can use and or you can use what? Known and unknown. You don't have to specify exactly who it was. And here Archie and Thomas is talking about, hey, wait a minute. We thought there was about 5 of them. Well, it was in our mind that they would have to prove these other 2, and all of them together, really, all 5 of them had to show that. But according to Idaho law, she didn't have to even know their names. And then it talked about when they were reading the indictment to the jury, they're talking about whether it would have been the defendant's wife named or another individual. It didn't matter what you told the jury in terms of the way that Idaho statutes line up on that. It didn't have to be so specific. But even then, y'all, the state laid it out quite clearly with Chad, Lori, and Alex. And it's my contention that I wouldn't be surprised if the jurors saw at least Zulema or Melanie Gibb and even Audrey Bartero is on the periphery of the conspiracy, but I believe we're just as guilty as Lori, Chad, and Alex. That's my view. So because the identity of a defendant's co-conspirator is not an essential element of conspiracy, the district court's failure to include the names of the conspirators in the jury instructions was not a constructive amendment of the indictment. Thus, despite pleading a conjunctive list of alleged co-conspirators in the second amended information, the state was not required to prove that all 3 co-conspirators agreed with Yang to commit the crime of trafficking in marijuana. It is settled by the great weight of authority that although an indictment charges a conspiracy involved several persons and the proof establishes the conspiracy against some of them only, the variance is not material. Thus, whether Yang's alleged co-conspirators were listed conjunctively or disjunctively in the jury instructions were immaterial. Proof that Yang had an agreement with any one of the alleged co-conspirators was sufficient. So even if Alex wasn't brought into it, if it had just been Lori and Chad, the bottom line is that it was 2 or more. Proof that Yang had an agreement with any one of the alleged co-conspirators was sufficient. Consequently, Instruction 18 did not deprive Yang of fair notice or prejudice his defense because the instruction identified the same alleged co-conspirators as the second amended information. Now, Archie is talking about there are 2 more that weren't even really talked about. It was all Chad, Lori, and Alex. But the bottom line is the state was very clear, y'all. Known and unknown. And when, in this case, in this precedent, they're talking about and or. So, again, when Archie talks about we were under the impression that there were 5 that were involved, of course he would have wanted all that brought out because the state's job would have been a lot harder. But then again, it wouldn't have because all they had to prove was Lori and Chad, really, ultimately. The defendant is making the same argument as the defendant in Yang. As provided above, this particular argument has been previously litigated by other defendants, and the various courts have clearly established any variance regarding the named co-conspirators or number of co-conspirators is not a material variance, since the burden with conspiracy is to prove only that the defendant conspired with at least one other person, not to prove an agreement between all the named conspirators or even the identity of the other co-conspirators. The defendant was on proper notice of the conspiracy charges against her. Now, the next thing that the state talks about is the court properly allowed for amendment of the indictment. And this, again, y'all, has to do with wording. And, it's going to go into all this. It's going to back it up with statute and code. But it talks about Idaho Criminal Rule 7E and Idaho Code 19-1420 governs the amendment of an indictment. Idaho Criminal Rule 7E provides the court may permit amendment of a complaint, an information, or indictment at any time before the prosecution rests if no additional or different offense is charged and if substantial rights of the defendant are not prejudiced. So what they're saying is again, this goes back to there's a rule in Idaho that has to go hand in hand with a statute code, right? And it provides that they can amend this up till they rest their case as long as they're not charging her with something more and it's not prejudicial. And so then it goes into Idaho Code 19-1420 provides an indictment or information may be amended by the prosecuting attorney without leave of the court at any time before the defendant pleads and at any time thereafter in the discretion of the court, where it can be done without prejudice to the substantial rights of the defendant. An information or indictment cannot be amended so as to charge an offense other than that for which the defendant has been held to answer. Now, the defendant references amendments which were made to counts 1, 3, and 7 of the indictment. Counts 1 and 3 charged the defendant with conspiracy to commit first-degree murder and grand theft. And count 7 charged the defendant with grand theft. In count 7 of the indictment, while the defendant was charged with grand theft pursuant to Idaho Code 18-2403, 4, Section A, the indictment included the language, by deceit and with intent to deprive, which is reflective of the language contained in Idaho Code 18-2403, 2, Section A. Now, this charge of grand theft is the same underlying grand theft referenced by the conspiracy charges in count 1 and 3. And the defendant was clearly on notice of the charge and allegations surrounding the grand theft and conspiracy charges, including conspiring to commit grand theft. So not only did what they're saying is she committed grand theft, but she conspired to commit grand theft. Those are two separate things. The requested modification from 4A to 2A, which was due to a clerical error, allowed for the code to accurately reflect the language in the indictment. There was no new offense charged by the amendment, nor was the defendant prejudiced. Idaho Code 18-204 4A provides this: a person commits theft when she knowingly receives, retains, conceals, obtains control over, possesses, or disposes of stolen property, knowing the property to have been stolen, or under such circumstances as would reasonably induce her to believe that the property was stolen, and AI intends to deprive the owner permanently of the use of or benefit of the property. Now let's stop there. The bottom line is, as Lori did, before she murdered the kids, she started taking the money. That money was intended for the care of those children. Tylee told her brother Kobe, she said, Mom's in control of my money now. The bottom line is the other one against theft against the United States government there. She knew damn well about that too. She knew it was stolen. She knew it wasn't hers. She concealed it. She didn't want no one to know that she had taken it. All kinds of evidence. All kinds of things. She sends Kobe money, pretending to be Tylee. The Social Security Administration. All of that. It wasn't just about her not reporting the death of the children, but also her marriage and other things. Now, it talks about Idaho Code 18-2403-2A, and it also talks about 18-2403-4A. And the amendment in this case was simply to correct the subsection within the same statute. If anything, this is what the state is saying, if anything, the state increased its burden to prove the theft was done using deception. So the state is saying, hey, not only was this not something that was going to cause her any harm, it wasn't going to look inflammatory to her, but it also made it a harder job for us, says Lindsay Blake, Rob Wood, Rachel Smith, and Spencer Ramel. This was going to be something more. We not only corrected this clerical error to line up with everything so it would be smooth, but also it even increased our burden to have to dang prove it. So it wasn't like we were doing it to make it easier on us. And then it talks about the defendant incorrectly indicates the modification changed in the intent from an intent to deprive to an intent to deceive. Under both subsections, the intent is consistent with depriving the owner of the property. So here we go, y'all. Of course, Archie and them are saying that this was wrong and all this and that. Of course, they're going to say that. But what happened is when they say intent to deprive, we're going to change that to the intent to deceive. Well, the state is saying under both subsections, the intent is consistent with depriving the owner of the property. Under 2A, the requirement is to only prove a defendant knowingly obtained control over the property, whereas under 4A, the requirement is to prove a defendant willfully exercised control over the property of another through deception. So when they're talking about intent to deprive, to keep something from someone, or an intent to deceive, not let them know, it's really under those subsections. It all it means the same thing in a lot of instances, because to deprive them, what you got to do is deceive them. And if you want to deceive them, what is that? You're depriving them, right? You've deceived them so they don't get the money. You're deceiving them or you're depriving them. It's all around the same thing. And it lines up with not only the criminal rule, but the statute that goes hand in hand with it. In State versus Bullis, the Idaho Supreme Court considered a modification of the Idaho Code on an indictment and found this. The indictment in this case sets out clearly and in language easily understood the facts sufficient to establish the jurisdiction of the district court, and the act or omission constituting the offense of which Bullis was convicted. The change in the code from Idaho Code 18-1402, which describes the difference between burglary, I can't say that word, y'all, but it's burglary in the first degree and burglary in the second degree. My tongue does not want to say that word. I don't know why. To Idaho Code 18-1401, which defines the crime of burglary in general, did not have the effect of changing the offense with which appellant was charged. It was easily ascertained, both before and after the amendment, of which appellant complains, what offense appellant allegedly committed and where it occurred. No substantial right of appellant having been affected by the amendments, and because the unamended indictment was initially substantially sufficient under Idaho Code 19-1418 and 19-1419, the trial court did not err in allowing the amendments which concern matters of form only. Similarly, the state in Dunn, the Idaho Supreme Court found The amendment did not charge a new or different offense, and it made no substantial difference as to the charge of obtaining money by false pretenses, whether the indictment stated appellant received the fictitious contract or executed it, because the balance of the indictment, both before and after the amendment, implied and it charged the appellant with having fabricated the contract. In State versus Severson, the Idaho court reiterated this. An indictment may be amended at any time before the prosecution rests without being returned to the grand jury, so long as doing so does not prejudice the defendant's substantial rights or charge the defendant with a new offense. Thus, an amendment that merely alleges additional means by which the defendant may have committed the crime is permissible if it does not prejudice the defendant. Let me just repeat that. It says it alleges that merely alleging that the defendant may have committed the crime in different ways. In other words, what? A right to deceive or to deprive. Does it really matter in Idaho code whether it's deceit or whether they're trying to deprive someone through the theft? In other words, as long as those two terms are used in the theft itself, they're not alleging another different kind of crime there. Then it talks about, when they're talking about the Banks case, they're permitting an amendment to information to include the age of a victim in order to reflect statutory rape as an alternative way of committing rape. So they're saying, again, the reason that the rape is brought up and everything is there's different ways to create rape. There's different ways to do grand theft. Depriving or deceiving by the hussy doesn't make a damn bit of difference, according to Idaho code and Idaho rules by that fact it too. It also talks about to permit an amendment adding additional means by which the defendant committed the crime of engaging in lewd and lascivious acts. And we're going back showing the examples that the state are showing, and this is about the rape. Engaging in lewd and lascivious acts with a minor was permissible because it did not prejudice the defendant's rights. Holding that an amendment to an indictment alleging alternative means by which defendant may have killed his wife was permissible because it did not prejudice the defendant. Holding that an amendment modifying the means by which the defendant committed sexual assault was permitted, and that was State versus Powell. And it's talking about holding that it was within the trial court's discretion to amend the indictment to include alternative means of committing first-degree murder. Factors relevant to determining whether the defendant was prejudiced include whether the amendment alleging the additional facts took the defendant by surprise, impaired the defendant's ability to adequately prepare for his defense, necessitated extensive further preparation by the defendant, or subjected him or her to double jeopardy. Now let's stop there. This comes down to Archie saying it's wrong. You put to deceive and to deprive, right? Well, first of all, they knew that the original wording was out there in the indictment. And not only that, when the clerical error was put together, a higher court or Judge Boyce, first with the district court, then a higher court would look at this. The bottom line is he has to look and say, now, when they changed this and said that it was a clerical error from deprive to deceive, did Archie and them have time to really get a case together? Well, he can look at the whole damn trial and see that Archie and Thomas didn't do shit. No, they gave the minimum amount of defense for Lori, which will stand up on appeal. But the bottom line is there was no big, huge change to deprive and grand theft or deceive and grand theft. You see what I'm saying? And obviously, Lori wouldn't have been subject to double jeopardy in this. The court found the amendment was permissible under standards of due process and Rule 7E because the defendant was not charged with a new offense, since the amendment merely alleges an alternative way Severson might have committed the crime. And it did not prejudice any of Severson's substantial rights. The amendment was made almost a year before the trial, and the defendant was aware the prosecution had advanced the theory that Mary died from suffocation. Now, while the indictment in this case wasn't amended until just before the close of the state's case, the defendant was on notice of the grand theft, was being prosecuted on a theory of theft by deception, and then the grand theft was the basis of the conspiracy to commit first-degree murder and grand theft. The plain language of the indictment put the defendant on notice of this, as well as the discovery provided to the defendant and the theory put forth by the state at grand jury. Furthermore, it did not change a new offense to two reasons. Number one, the actual charge was conspiracy to commit the first offense, and two, the amendment was merely an alternative way and an alternative subsection by which the crime of grand theft can be committed, not a new charge. Again, y'all, the state, they changed it, but it was just an alternative theory about it. And the bottom line is Archie and Thomas should have known and looked at all the areas of all the discovery to see where the state could have come in on this. And it's backed up by statute and precedent that you can give an alternative correction. A clerical error can be, changed from deceive to deprive or deprive to deceive. So that's another thing that the state is talking about. And finally, y'all, the jury instructions were not confusing, and there is no support for the assertion that jurors considered evidence not presented during the trial. And this has to do with a couple of things, but y'all might mainly Saul Hernandez. The defendant is simply attempting to twist a post-trial media interview of a juror to support her misplaced argument that the court misdirected the jury on a matter of law or erred in the decision of any question of law arising during the course of trial, and or that the jury received evidence out of court. Post-trial evidence as to juror post-conviction statements is inadmissible and prohibited under Idaho Rule of Evidence 606. Idaho Rules of Evidence 606b1 provides this, y'all. Prohibited testimony or other evidence. During an inquiry into the validity of a verdict or indictment, a juror may not testify about any statement made or incident that occurred during the jury's deliberations, the effect of anything on that juror's or another juror's vote, or any juror's mental processes concerning the verdict or indictment. The court may not receive a juror's affidavit or evidence of a juror's statement on those matters. Again, they can't, after there is a conviction, there's a guilty on all counts of Lori, they can't come back and get an affidavit from a juror and start this whole damn thing. It's against Idaho law. Idaho Rules of Evidence 606b2 provides some exceptions to the exclusion of the juror's testimony. However, none of the exceptions to the prohibition of using a juror's extrajudicial statements to collaterally attack a conviction apply to the arguments presented in the defendant's motion for a new trial. The court should refuse to consider the defendant's point as the juror 8's or any other juror's statements to the media post-trial. Again, y'all, extrajudicial means after this trial's over, a verdict's been reached, the jurors left, they go out on national TV or go to East Idaho News. Those are extrajudicial, okay, comments. But the state wants to cover their base, so they say even if the court were to consider the statements purported by the defendant to support her attack on the court's instructions and evidentiary rulings, the defendant's motion fails on its face. As provided by the defendant in her motion for a new trial, Juror 8 stated, quote, "We didn't consider this during our deliberations because it was clear to us the instructions were clear," unquote. Arizona evidence and testimony is only for demonstrative purposes, says this Juror 8, i.e. Saul Hernandez. During the follow-up interview with that same juror on May 30th of 2023, the interviewer, Nate Eaton, asked if Saul Hernandez found the jury instructions they were given confusing, and Saul Hernandez responds, quote, "I personally did not. I thought the judge gave us instructions throughout the trial, throughout the process, multiple times, with those instructions never changed in my opinion, even up to the very last date. Up to the moment before we were released to go deliberate. The instructions were clear." Then the state says there is no actual evidence to support that there were any confusion regarding 404B evidence and any demonstrative evidence. It is clear Juror 8 is unequivocal in stating that the jury instructions were clear and the 404B evidence which was introduced was not considered for any purpose other than in compliance with the instructions provided by the court. The defendant erroneously concludes that the juror must have relied on a body cam video of Charles Vallow's interactions with law enforcement, which was not presented during the defendant's trial. During the first interview with the juror, there is not an indication as to when the juror watched the body cam, whether before or after the trial. However, in the follow-up interview on May 30th, Juror 8 explained he was released from his obligations as a juror on Friday after the verdict was rendered. The following Sunday, he watched a new episode of a show referencing the case, which was the first time he saw the body cam footage of Charles Vallow, which he referenced in his first interview. He was very clear that he did not view any outside evidence during the trial. Outside of the fact Juror 8 is unequivocal that the court's instructions were clear and followed, the Idaho Supreme Court has previously determined the impeachment of the verdict by affidavits made after verdict rendered has never been recognized by this court. And again, y'all, when we talked last time, I was like, would they have this Saul Hernandez come into court on this Thursday when they hear this motion hearing for Lori's new trial? And the fact is they say right here, it's never been recognized by the court. So he's not, even though the state brings him up, it's not of any importance. Applying this analysis of affidavits being insufficient to impeach a verdict, use of an interview of a juror would fall short of meeting any requirements to show actual support for setting a verdict aside, as outlined by both Idaho Rules of Evidence 606 and jurisprudence of the Idaho Supreme Court. Additionally, in State v. Alwyn, the defendant's motion for a new trial based on the admission of a trimmed-down booking photo was denied. The court reiterated, photographs showing the appearance of a person are generally admissible in the discretion of the trial court unless the photograph is so inflammatory that its probative value is outweighed by the prejudice which might result from its inflammatory nature. And what we're talking about here is 404B what? Exhibits. Anything that the jury's members saw. It wasn't just testified to, and the juror's like, oh, wait, they're starting to talk about Lori in Arizona. That's one type of evidence and testimony of 404B coming in under what? For motive. But also, they're talking about this other situation where as long as it's not so inflammatory, and the bottom line is the state's making this clear in the 404B, visual, demonstrative exhibits that pointed out things in Lori's past, i.e. Arizona, her behavior, her pattern. Then it talks about State versus Carter. Such photos used to describe a person are admissible for the purposes of explaining and applying the evidence and assisting the jury in understanding the case. Internal citations omitted. The court determined that use of the mugshot, which has been trimmed down, was proper in assisting the jury in understanding how the officer identified the defendant, and the use of the photo was not prejudicial to the defendant. While the photo was not determined to be 404B evidence, a similar analysis was applied regarding the relevance and any potential prejudice to the defendant. Of course, if it had been determined to be 404B evidence, a different analysis would have been applied to determine the admissibility, and a limiting instruction would have been given. In this case, though, the jury was instructed multiple times regarding the use of 404B to be considered for limiting purposes. The court instructed the jury each time 404B evidence was being introduced, and subsequently provided the following instruction. This is what Judge Boyce said to him more than once. Jury instruction 14. Judge Boyce told the jury in Lori's trial here, evidence has been introduced for the purpose of showing that the defendant committed acts other than that for which the defendant is on trial. At the time of this evidence was introduced, you were advised of its limited purpose. Such evidence, is, if believed, is not to be considered by you to prove the defendant's character or the defendant has a disposition to commit crimes. Such evidence may be considered by you only for the limited purpose of proving the defendant's motive, intent, preparation, plan, knowledge, or absence of mistake or accident. So let's just say this very clearly. When Lori was doing all this shit in Arizona, and I contend even back with Joseph Ryan, but let me tell you what, it shows it quite clearly. This stuff that her and Alex did, and I believe Chad helped them along too, the bottom line is she had a motive for doing that. Murdering Charles Vallow. Just as she had a motive all the way through to try to murder Brandon or try to take Tammy out before the deed was finally done. And obviously the murder of the children. The intent of it. Lori's intent to murder Charles Vallow in Arizona was for money, just as every damn thing else down the road. Preparation. You know she was prepared. Her and Alex were prepared to do all of this. They set a trap for him. It's clear as crystal. As they set a trap for everything else. Moving the children away. Getting them away from people that knew them. All of it just sinks all together. Then you got the plan. It's clear as crystal. Again, through text messages. Their physical behaviors. The things they did. The knowledge they knew. When Lori and Alex left Arizona, and Chad knew too, but when they left, they knew they had left a murder behind. They thought they had gotten away with it. They were running from it. Or absence of mistake or accident. I guarantee you, there was no accident in any of it. They purposely wanted to murder these people. They thought they had gotten away with Charles as They hoped they could get away with the rest of it. And folks, there was no accident. As we clearly know through the evidence, there is no accident that Alex accidentally walked up on Charles after shooting him once while he's laying on the floor defenseless and shooting him again. And there's nothing accident about where we see Tammy and the children and what happened to them. The court provides a separate instruction regarding demonstrative evidence, which specifically identifies the demonstrative exhibits. Again, 404B. Not only are they made aware of it, they have testimony of people that talked about Arizona, but they've also got things that the jurors can see. Jury instruction number 15. Certain evidence was admitted for a limited purpose. At the time this evidence was admitted, you were admonished that it could not be considered by you for any other purpose other than the limited purpose for which it was admitted. This includes those exhibits admitted for demonstrative or illustrative purposes only. Do not consider such evidence for any purpose except the limited purpose for which it was admitted. The following exhibits were admitted only as demonstrative or illustrative exhibits, and they go down a whole list of them, y'all. These exhibits are available for your review during the deliberations upon your request. Please advise the bailiff by written note or any other request. The instructions provided by the court regarding the 404B evidence and the demonstrative exhibits were very clear. The defendant's assertion regarding this potential ground for a new trial fails as there is no proof jurors considered information or evidence which was not introduced in trial. With regard to any allegations, the instructions from the court were not clear. This assertion from the defendant also fails given the instructions were clear, and also given the same juror, the defendant attempts to use statements from to establish the instructions were not clear. Unequivocally stated, this Saul Hernandez in both of his interviews, that the instructions were clear, and the court reiterated them multiple times. In conclusion, due to there being no valid support for any of the grounds outlined in Idaho Code 19-2406, and there being no support that it would be in the interest of justice pursuant to Idaho Criminal Rule 34, the defendant's motion for a new trial fails. Wherefore, the state respectfully requests this court deny the defendant's motion for a new trial. And Thursday, they might go into a little more specificity about things, but it's highly doubtful. It's not going to go anywhere, in my opinion. The judge is going to look not only at Archie's belly aching, but he'll look at all 7 of those in Idaho statute. Obviously, when you're talking about that the court erred, the Judge Boyce is going to have to say, oh, I erred. I doubt that very seriously. Every decision that he made was not from the bench. And in fact, a lot of us got a little ill about the fact that he's like, I got to go meet with my staff attorney. He wanted to make sure that any ruling that he had would be what it was. So that is legality. That is the legality of what we've got Thursday. The legality of Idaho saying that only a few of these people are considered by law victims, and that Larry Woodcock, Annie Cushing, Crusher K. Easton, and others are not victims is a crock of shit. That's why Wednesday's Ray Room chat is going to throw law right out the window when it comes to the subject and content matter of why Lori does not deserve a new trial. Remember, take your mind, focus in on the lens. We're not looking at laws at all. That she broke laws. That's why she shouldn't get a new trial. Let's look at other things. It's not as hard as you think if you really, really focus. Also, why does Lori need a life sentence, which her sentencing is coming up July 31st? Why Chad should get the death penalty? Why should Chad Daybell get the death penalty? Let's not look at the law on it. Let's look at all the other things that old KJ's going to spew out of my mouth with colorful language, I'm sure, on Wednesday. And I'm putting a post on the community wall to allow you to get that out. Just remember, y'all. Just remember, the law is the law. Man's law is not God's law. And there seems to be some things that don't seem like justice to me when it comes to the definition of a victim, obviously. Also, will Judge Boyce, will he, if you put law aside, he is the administrator. He is the one that has to look at the law and make sure everything's done properly. Would he even look at this in sentencing and say, she deserves, maybe after 30 years, parole, which y'all know is a crock of shit, but let's just do this for sake of argument. We're talking about a danger to society. If she was paroled, what would happen? Let's use our inner thoughts and feelings, our perspectives, to delve into that. Chad getting the death penalty, a deterrence of other religious or fanatic cult-like, a deterrence for them, these nut jobs out here, would that help at all? To know that one of these people are on death row? I think we need Chad Daybell on death row. Idaho stands up, finally, to all this crazy shit going on. You got Brian Kohlberger all these crazy ass people in Idaho, and trust me, there are a lot of good people in Idaho, don't get me wrong, but it seems like a lot of crazy ass people are just, oh, well, they can't even implement the laws on the books. They can't even put the death penalty laws. They got the firing squad out there. You think it's ever going to happen? Robin Rowe, other people. When's the last time Idaho's damn put anybody to death? Well, I'll tell you what. This Wednesday we're going to go to town. We're going to throw law out the window, man's law out the window. We're going to talk about it, be looking at the community wall. You got something to say, you might as well say it, because it's coming out on Wednesday evening. So anyway, I love you all. I got through it. I hope I made sense. But I'll tell you one thing I know is simple, and I know you can understand. I love you, and keep on looking.